Welcome to From Separation to Settlement, a family law podcast.
Hello and welcome back to From Separation to Settlement. I am your host, Kevin Rosenquist, and I'm joined by Jeffrey Hale, a litigation partner at Kroner Hale Law Firm. Jeff has dedicated his career to guiding families through divorce, custody, and other complex legal challenges with compassion and clear, honest advice. In today's episode, we're going to break down the basics of family law, what it covers, what first steps you need to take if you're facing separation or custody issues, and why having the right legal guidance makes all the difference in the world. Jeff, welcome back. Great to see you.
Kevin, great to be back. Thank you.
So last episode, we got the introduction to you and how you got into this and what your approach is. Now we're going to get a little more detailed. So for someone who's new to the process, can you explain in simple terms exactly what family law covers?
Absolutely. Family law is it's a generic term. It's just kind of a catch-all because for in our practice, family law covers custody, it covers child support, covers divorce, it covers pre-decree, which is everything during the divorce until it's finalized. And it also covers post-decree, which after a divorce, there may be disputes over parenting time or bills not being paid or whatever the divorce decree would have ordered may not be getting done. So post-decree would be motions for contempt and any motions after the divorce was finalized, but there are still problems arising.
Okay. And when it comes to divorce, what's the first legal step that someone would take if they're going down that road?
So it depends, because when you come in and you begin to talk about what it is you're hoping to accomplish, part of our roadmap that we discussed in the last episode is that we want to know what it is that you want to accomplish, because there are uncontested divorces, there are contested divorces, and then there are dissolutions. There are also annulments. Annulments are a rarity just because there's restrictions on annulments because it basically wipes out the record of the marriage. So there are very, very limited exceptions that allow you to do that.
Has to be done pretty quickly too, right? After the wedding?
It does.
After the marriage?
Yeah. So it's there are very, very limited exceptions. And so we focus mainly, obviously, on divorce, uncontested, contested, and dissolutions. So when you come in, the dissolution means that you believe you're going to be able to agree on everything. So there's not a dispute. So really at that point, the first legal step would be to bring that person in, and you have to put together a separation agreement. If they have children, you need to talk about, is this going to be shared parenting? Is this going to be sole custody? And then you'd either put together a shared parenting plan or you'd put together a parenting agreement. And so we sit down with our clients and we put together a separation agreement. And it's basically that deals with all the assets, all the debts, anything that is not child related is in the separation agreement. So we'll put that together. Then we will send that out to their soon-to-be ex-spouse, and if that individual has an attorney, then we would submit it to that attorney as a settlement offer. So that in a dissolution, that would be the first legal step in a sense. Well, the court's not involved at that point, but it's a legal transaction, because with a dissolution, everything is done up front before the court actually gets involved. So you do all the separation agreements, you do all the parenting orders, everything is completed when you show up and file it with the court. Then you have a complete agreement. All you're waiting on is to get a court date to have a quick hearing, and the court will dissolve your marriage. Now, divorce is different. The first legal step with a divorce is filing a complaint and a petition for divorce. With that's going to trigger the court. That triggers the court that there is a legal action. Someone is suing for divorce, and the court is going to issue temporary restraining orders. Now, that sounds a little more harsh than it is. It's more just a status quo order, which means to keep things the way that they were during the marriage until the court can review and see what's going on and get an idea of, what the parties are looking for, what they have, and where they stand. So that would be the first step, but that would be obviously be followed up with The court requires affidavits, affidavit of income and expenses, property affidavits. And then 9 times out of 10, with most clients going through a divorce, we also file, it's referred to in Ohio as a 75N order, which is a request for temporary orders, which will deal with things like payment of marital expenses, child and parenting issues. It'll deal with if there's a request for spousal support, and it deals with child support. Now, those are temporary, but it's basically meant to be a bridge to get you from filing for divorce to the final decree.
Okay.
So it's kind of a gap fill until you can get to the final order.
Okay. You mentioned before contested and uncontested divorces. I'm sure we're going to get into this more detail in future episodes, but just from a high view, what exactly is the difference?
So an uncontested divorce ultimately comes in. The reason you suggest those is if someone has an issue and they're afraid that someone's going to hide money or someone's going to abscond with the children or just stop paying things or shut off the electricity. Filing as an uncontested divorce it triggers the court, it gets the temporary restraining orders, it gets you the avenue to file for temporary orders. The dissolution does not typically set that up because everything's done up front. You're trusting that person to maintain the status quo or to follow whatever agreement you've come to while you're going through this. But the uncontested divorce gives you access to the court if a problem arises, but then ultimately uncontested, you work out an agreement, you submit it to the court, and you have a quick hearing, and it basically works like a dissolution, only it gives you access to the court much earlier. And then contested is exactly what it says. There are items that you cannot agree on, so you have to present evidence to the court and let the court make the decision.
Okay, got it. That makes sense. Obviously, when kids are involved, it complicates things. Custody is a huge concern for parents. What are the factors that really matter to the court as far as how they approach custody decisions?
In Ohio, I believe it's ORC 3109, but they deal specifically with determining parenting rights and responsibilities. And there's a list, I believe it's around 12 or 13 factors that the court goes through to determine what's in the best interest of that child. So the courts will use that, and obviously each party will present, if they can't reach an agreement, each party will present evidence specifically triggered and focused on those certain things. You want to look at the child's adjustment within the family. You want to look at items like who's been the main care provider. You want to look at how the child has adjusted to the community and how basically even when separated, how far apart are the parents going to live, to determine is shared parenting an option? Is there going to be too much distance to make it a reasonable option? You want to look at if someone's ever been charged with domestic violence involving the family members, one of the children, or your soon-to-be ex-spouse. So there's several factors that go into this, and that the court will have to consider. They'll make decisions on that, and then ultimately, sometimes depending on the age of the children, you may need a guardian ad litem who is an attorney for the children, and they will investigate and speak with the children and speak with the parents. And if you have witnesses that you would like the guardian ad litem to speak with, they will go meet with those individuals, and they want to gain as much knowledge and as much information so that they can issue a report to the court on what they found out. And all of this then will get factored in by the judge if they're ultimately going to make that determination.
How much weight, if any, does the kid's preference have on custody?
So it can be a factor, but there used to be, and I mean, it may still be, that the kids get to choose. There's some magical certain age they get to choose where they want to live, and that's just not the case. Now, they can either it's referred to as an in-camera interview where they meet with the judge, and typically if there's a guardian ad litem, the guardian ad litem will be present, or a child protective services agent will be present, and just for the judge to talk to the children to get an idea and a feeling. Now, they to my knowledge, those are secret conversations, but to my knowledge and my understandings, they never ask them where they want to live. They just ask them about both homes and, their comfort level of both homes and their development and their ties to the school or whatever neighborhood maybe each parent may be residing in at that time. It's similar is questions, along those lines. And
Yeah.
so the older the children get, the more reasonable it may become, depending on the circumstance, to have a child testify because as the child gets older, they're better able to articulate, if why they want to stay in one place versus the other. And they're able to give good reasons, not just, oh, mom's a better cook or dad's a better cook. It's,
Yeah.
they
I
can
get more candy when I go to dad's house.
yeah, they can give you a legitimate reason
Right.
and
Yeah. Right.
understanding for why in their head this is better for them.
How are property, assets, debts? Is there any sort of a formula for how that stuff is divided in a divorce in the state of Ohio?
Yeah, so the starting point is they refer to it as equitable distribution. Now, I would say probably 9 out of 10 times that's an equal distribution. So the court will you have the date of marriage, which obviously is on the marriage license. The court will choose, if you don't agree, the court ultimately has to decide a date of separation. Now, everything between those two dates is considered marital property. Now, there are some exceptions for things that were separate property prior to the marriage that you've maintained their identity and you can trace them, or if one party inherits from a family member, that remains separate. That always goes to that person as long as you can trace it and identify it. But typically, it's an equitable distribution, and 9 times out of 10, like I said, that's an equal distribution. But that can be, depending on the evidence, depending on other factors within the case, that basically that equal needle can move left or right depending on how a party's behaving. There are things that you can get into that can move that equal distribution needle if there's been financial misconduct. Now, typically, stepping outside of the marriage is not considered unless somebody was expending marital money to carry that on.
Makes sense.
And then that can be a trigger for financial misconduct during the marriage. So other than that, I would say it's going to be a situation where it's pretty equal distribution. If everything considered and everything's pretty on the level, then it's going to be an equal distribution.
Can you kind of explain how spousal support, formerly known as alimony, works? When is someone eligible for spousal support?
So they're, oddly enough, and you would think that eventually they would just make a simple formula. Child support is income and some healthcare expenses, but typically it's just income in, and it spits out a number the state has decided is what it takes to raise X number of children. Spousal support's not like that. Spousal support is very case specific and sometimes is very judge specific. So there have been judges that have, kind of created at least in their rulings, they have created almost a formula that you can see develop and you can estimate based off what you're seeing their other rulings as to what someone may get. So spousal support is determined. It's also in the statute, but it doesn't give a formula. But there are points that you have to hit. There are factors that are considered by the court. The length of the marriage. They consider the earning abilities of the parties. They consider if one party has sacrificed their career in order to support the operations at home to allow the other party to advance their career and to make those jumps. So they take these into consideration because everyone goes into it thinking that this is going to be forever. Mm-hmm. So when you're making that sacrifice and okay, I'm going to stay home and I'm going to take care of all the work that happens at the house, which is a huge job. And I'm going to let you go out into the world and you're going to earn all the money. Your career is going to advance. I'm going to support that by always being here. I'll deal with this. You deal with that outside world. And when the family, when this family finally breaks and they're separating or they're divorcing, the court's got to take that into consideration. That's a very big factor because had it not been for that sacrifice, this individual may have not reached that point. Mm-hmm. And if they had not sacrificed, maybe the individual that stayed at home would have a much higher career, making much more money and able to support themselves. But because of the sacrifice they made, then they're unable to support themselves at this time.
Yeah. That's a good point. That's a good point, because if you make that deal, one person's, career, as you said, is going to be put on the back burner, and they shouldn't be punished then because they made that decision as a family if things end up ending.
Yeah, so. Absolutely. And you would be surprised the number of, I've been on both sides of it, and it's still surprising the number of, I'm referring to them as the breadwinners in this family. They truly believe that money is theirs and that they did this all on their own. And sometimes it's mind blowing. You can't, it's hard. Now, when you're on the side of the breadwinner, it's really hard to explain to them why this is going to happen.
Yeah. It's almost like it's hard for them to see how tough that other job is and how important that other job was and how that deal was made, whether it was talked about or even if it was just sort of implied by how the family unit kind of moved forward. So I could see that being tough if someone's like, "Hey, it's my money." Be like, "Well."
Yeah, and that's always a hard conversation. So that's okay. Typically where the listening and letting the anger spew for a while comes in handy.
Speaking of that, for if there's anyone listening who is very overwhelmed, by everything that comes with divorce or custody battles, is there one step that they can take today to start moving forward and maybe start to get their emotions under control?
I would say if you're overwhelmed, for me, the first step would be just to reach out to an attorney wherever you're located. Find if you have friends or family members that can suggest somebody, but reach out to them and just get a baseline of what your rights are, because most people don't understand that even if your name's not on the title of a home or the title of a car, and even if you haven't been paying the mortgage because you've chosen to do all the work at home, which we all know does not pay, you still have rights. You have equal rights in that vehicle. You have equal rights in that home. You have equal rights in retirement that's been earned by another party. So I'd say the best thing they can do is initially just reach out to an attorney and say, "Hey, I just want to know what my rights are. This is my situation. Where am I likely to land in this?" Mm-hmm. And our office, I know, has free consultations, and most offices do. So it costs you nothing to get information. And hopefully that's what this podcast will do for some people once we get into if we get into details and depths in other episodes.
Yeah, for sure. Well, great tips as always, Jeff. And thanks for listening to this episode of From Separation to Settlement. If today's conversation gave you some clarity, please be sure to subscribe, leave a review, share the show with others who you feel might benefit from our conversations. And to learn more, schedule a consultation with Jeff, visit kronerlaw.com. Jeff, it was so good chatting with you again. Thanks so much for all the insight.
All right. Thank you, Kevin.
Thanks for watching. Be sure to hit that like and subscribe button and leave us a review in the comments.